There's big news coming from the Supreme Court today, announcing this morning it will take up a major Second Amendment case.
The Supreme Court said that the Second Amendment does provide an individual right to have a gun.
The nation's highest court has ruled that Americans have a right to carry firearms in public for self-defense.
We believe the right to keep and bear arms shall not be infringed, period.
I'm the strongest Second Amendment candidate running. Trump, he had to be reeled in from violating the Second.
Justice Clarence Thomas recently, who said that he believed the court now considered the Second Amendment, Kate, a disfavored right.
The Supreme Court just struck down every firearm permit requirement in America. Every single one. Purchase permits, carry permits, ownership licenses, waiting periods disguised as safety measures, mandatory training as a condition of permission, all of it. Gone. One decision. The case's National Association for Gun Rights v. United States decided this morning at 6:23 a.m. Eastern. It is the most consequential Second Amendment ruling since District of Columbia v. Heller back in 2008. I'm going to break down exactly what this means for you, what your state is already planning to do about it, and why the next 6 months matter more than the ruling itself.
There's big news coming from the Supreme Court today, announcing this morning it will take up a major Second Amendment case.
Representative Jim Jordan strongly defended the Second Amendment, which he claims Democrats want to get rid of.
The Supreme Court said that the Second Amendment does provide an individual right to have a gun.
The nation's highest court has ruled that Americans have a right to carry firearms in public for self-defense.
Alright, so let me tell you why this hits you personally. If you live in Massachusetts, New York, New Jersey, Illinois, California, Connecticut, Maryland, Delaware, or Rhode Island, the system your state built to control whether you could own or carry a firearm just got declared unconstitutional. If you've been waiting 4 months for a carry permit, you don't need it anymore. If you were denied a pistol license because some bureaucrat decided you didn't demonstrate proper cause, that system is gone. If your state charged you $200 and made you wait 60 days just to get a card that says you're allowed to own a rifle, that card no longer exists as a legal requirement. Over 180 million American adults just had the practical ability to exercise their constitutional rights restored without asking government for permission first. That's not rhetoric. That's what the court held. And if you think your state is going to accept this quietly, you haven't been paying attention.
To carry those concealed weapons in public, to actually show what they call an actual or articulable need to carry the gun.
The Ohio Republican decried any effort to ban assault weapons and proposed red flag laws.
States cannot put these special restrictions on getting a gun for a concealed carry permit.
I don't think this was entirely a surprise that it came down this way, but it is potentially a momentous decision.
Here's what the court actually said, and this is critical because the media is already mangling it. The holding is straightforward. The Second Amendment protects a pre-existing individual right. Government cannot condition the exercise of that right on obtaining bureaucratic permission. That's the court's language, not my interpretation. They drew a very specific legal line, and you need to understand it. Government can verify your eligibility through instant background checks. What government cannot do is require permits, licenses, or approval processes that delay or deny the exercise of your rights. Verification is not permission. Those are two completely different legal concepts. One is the government checking whether you're legally eligible. The other is the government deciding whether to let you. The court said permission systems violate the Second Amendment. Verification systems don't. That's the line. That's why this wipes out every permit requirement in the country.
Justice Clarence Thomas recently, who said that he believed the court now considered the Second Amendment, Kate, a disfavored right.
We believe the right to keep and bear arms shall not be infringed, period.
Amendment, look, I'm the strongest Second Amendment candidate running. Trump, he had to be reeled in from violating the
Justice Antonin Scalia, he wrote for the majority, and it established this individual right to keep guns at home for self-defense.
Let me walk through specifically what's now unconstitutional. Massachusetts FID cards, which you needed under Chapter 140, Section 129B just to own a long gun, gone. Massachusetts LTC licenses for carrying, gone. New York's pistol permit system under Penal Law 400.00, where a licensing officer had unlimited discretion to deny you, gone. Illinois FOID cards under 430 ILCS 65, which functioned as a gun owner registry, gone. California's 10-day waiting period beyond actual background check processing time, gone. New Jersey's handgun purchase permits under NJSA 2C58-3, gone. Connecticut's permit to purchase system, gone. Maryland, Delaware, Rhode Island, all of their permitting frameworks, unconstitutional under this decision. Now here's what's still legal, and this matters just as much. Background checks survive. NICS, the National Instant Criminal Background Check System, still operates. You still cannot purchase a firearm if you're a convicted felon, if you've been convicted of a misdemeanor crime of domestic violence under 18 U.S.C. Section 922 grams 9. If there's an active protective order against you, if you've been adjudicated mentally defective by a court, or if you're an unlawful user of a controlled substance with a formal adjudication. Federal age restrictions remain. You still need to be 18 for rifles and shotguns, 21 for handguns from a licensed dealer under the Gun Control Act. Federal firearms licensees still exist. Dealers still run background checks. Sensitive place restrictions survive. Federal buildings, courthouses, schools under the Gun-Free School Zones Act. 18 U.S.C. Section 922Q. Airports all still restricted. The court didn't say you can carry anywhere. It said you don't need government permission to carry generally. That distinction is everything. Let me put this in the context it deserves, because this didn't happen in a vacuum. In 2008, Heller v. District of Columbia recognized the Second Amendment as an individual right. Massive. But it left open what regulations were reasonable. In 2010, McDonald v. City of Chicago incorporated that right against the states. Handgun bans became unconstitutional, but permit systems survived.
Core reason for the Second Amendment is to provide law-abiding citizens with the ability to carry a gun for self-defense.
I want to buy a bazooka, and I found a good deal on one in Europe.
The fact that gun rights, it's now at the forefront of the public discussion. We could see Congress take some action on this.
People have all of a sudden is illegal and you're a felon for something that you legally purchased. That is a gross abuse of power.
Then in 2022, New York State Rifle and Pistol Association v. Bruin. That's the case that changed the analytical framework entirely. Bruin established the historical tradition test. Any firearm regulation now has to be consistent with America's historical tradition of firearms regulation as it existed in 1791 and 1868. Permit systems for private firearm ownership? They didn't exist in 1791. They didn't exist in 1868. States had militia muster requirements, sure, but not bureaucratic permission slips for private ownership. Bruin opened the door. This decision walks through it and doesn't look back. The court held that permission systems are prior restraints on a constitutional right, and prior restraints are unconstitutional. Full stop.
High Court this morning saying that Americans have the right to carry guns in public.
The Supreme Court has said in Heller that is a personal right. It's not a right that is tied to being in a militia.
The ruling is expected to allow more people to legally carry guns on streets of the nation's largest cities.
Are firearms used in self-defense, Ms. Okafor?
Yes, 1.6 million every year.
Now let me be honest with you about what this is and what it isn't. Is this a total victory in terms of the legal principle? Yes, it's enormous. But in terms of practical reality, this is where it gets complicated. Every gun control organization in the country is already strategizing workarounds. Every town just announced a $50 million campaign for what they're calling alternative safety frameworks. The Brady campaign is already publishing model legislation for states. Here's what that looks like. They can't call it a permit, so they'll call it an eligibility verification certificate. They can't impose a waiting period, so they'll create a processing window for a new documentation requirement. They can't require a license, so they'll build a registration system and argue registration isn't permission, it's just record keeping. Every single one of those strategies is designed to recreate the permit system under a different name. And every single one will be challenged in court.
Gun rights and the Second Amendment were front and center at the Supreme Court today.
Made clear that gun control is not an area that the Civil Rights Division under any administration.
I think that someone who is not otherwise prohibited should be issued a concealed carry permit without any problems at all.
Some of those more populous states, those states that require that extra hoop that you have to jump through, that's unconstitutional.
Because the legal principle the court just established doesn't care what you call it. If it functions as permission, if it delays the exercise of a right, if it gives government discretion to deny, it's unconstitutional under this ruling. Expect hundreds of lawsuits in the next 2 to 3 years. Expect California to announce emergency legislation within weeks. Expect New York to attempt new restrictions before the summer is over. Expect Massachusetts to rebrand their entire system and dare someone to challenge it. That's how government responds to court decisions it doesn't like. It doesn't comply. It transforms. Here's what you need to do right now. First, verify you're not a prohibited person. If you have felony convictions, domestic violence misdemeanors, active restraining orders, or court-ordered mental health adjudications, this ruling changes nothing for you. You're still prohibited under federal law. Second, if you're clear, exercise your rights. Walk into a gun store, pass your background check, walk out. If you choose to carry concealed, you no longer need a permit anywhere in the country. Third, document everything. Keep your background check approval records, get receipts, timestamp your purchases, because when states start enforcing new systems they haven't passed yet or arresting people under laws that are now unconstitutional, your documentation proves compliance with actual constitutional law. Fourth, get training. The court said government can't mandate it as a condition of rights. That doesn't mean you shouldn't do it. Competence is your responsibility now, not the government's. Be serious about it. Fifth, support the organizations that are going to defend this decision. The Second Amendment Foundation, the Firearms Policy Coalition, Gun Owners of America, they spent millions getting here. They're about to spend millions more fighting every workaround every state invents.
New Jersey and other states, people calling up and saying thank you because it's ultimately going to affect us here.
We enforce the laws that Congress gave us, and weighing in on Second Amendment and gun control
is thinking that, there's something not quite right here about what's going on.
We can expect in the future that more people will be carrying handguns on the streets in places like Los Angeles.
2008, the court was divided over what the right in the Second Amendment meant.
Here's where things stand right now. As of this morning, every permit requirement in America is unconstitutional. Background checks remain. Prohibited person categories remain. Sensitive place restrictions remain. Your right to own and carry a firearm without government permission is restored. But your state hasn't accepted that yet. Watch your state legislature. Watch for emergency sessions. Watch for bills with new names that do the same old thing. This ruling is the beginning of a legal war that's going to define your rights for the next decade. That's it for today, folks. I'll be tracking every state response, every new bill, every legal challenge as they come. See you in the next video.